While Supreme Court justices are jetting all over the world on fancy private family vacations paid for by right-wing billionaires or collecting hefty cash gifts from those billionaires for their personal museums and family members' private school tuition payments, the GOP says the real problem in our legal system is that too many victims of corporate wrongdoing are finding access to the courts in the first place. Justice is a rich man's game in this court of billionaires. The Bill of Rights has mostly been left in the dust. On the Roberts Court, justice is indeed blind, but only to ethics itself. It is deaf to the pleas of women and working people, and it is dumb in its refusal to see how it has destroyed its own legitimacy in the eyes of the public.
What we have here is a court that has debased and delegitimized itself. I personally believe that Clarence Thomas should be impeached beyond a shadow of a doubt. I am astonished that this is a position that is in any way controversial to anyone. The degree and extent of misconduct that Clarence Thomas alone, in addition to several of his colleagues have participated and engaged in, is foundationally delegitimizing to the Supreme Court. And it is our responsibility, our constitutional duty to rein them in.
It is important to note that our most fundamental rights have never been safe, and they never will be guaranteed so long as they depend on the ideological whim of 9 unaccountable, unelected justices with lifetime appointments. It is why we need to limit the power of justices by expanding the court, instituting term limits, enacting a code of ethics, and it reinforces why Congress should strip the court of the right to take away fundamental rights.
So to sum all this up, back in 2009, as the Supreme Court prepared to decide Citizens United, one Nazi-obsessed vacation funding billionaire named Harlan Crow began funding Federalist Society leader Leonard Leo's scheme with Justice Thomas's wife to exploit the anticipated outcome of her husband's rulings. Their goal was to build a right-wing money machine allowing billionaires to fund changes to the judiciary and overturn years of judicial rulings they disagree with, from abortion to environmental protections to LGBTQIA+ rights.
Now, I think my colleagues, of course, might be projecting. Big corporations, as we all know, are doing just fine. Meanwhile, Republicans are willfully ignoring the fact that wealthy conservative donors are lavishing gifts on the conservative justices of the Supreme Court. Now, Republicans claim to be concerned with outside money influencing the legal system, but only when it hurts their corporate backers. When right-wing billionaires create conflicts of interest for the highest court in our country, they are completely silent. So I look forward to the many hearings that we have on Clarence Thomas and the justices and their illegal gifts that they're receiving and not disclosing.
We are talking about a court with the majority of justices appointed by a party that has not won a popular presidential election more than once in 30 years, ruling against the majority of Americans. We have a Senate that is controlled by minority rule. And we have a House suffering from the impacts of gerrymandering that amplifies and undermines our democracy. We are in a very dangerous moment, not just for women, not just for LGBT communities, not just for all of us, but we are in a dangerous moment in the world because this is not just about the right to choice. This is about rule of law and democracy.
Mr. Chairman, I spent my recess traveling across America. I was in 10 states, including your beautiful Kentucky. And one thing I found is that all over America, people are in an uproar over the money that billionaires are spending to influence justices on the United States Supreme Court. Americans see that personal gifts to justices from right-wing billionaire sugar daddies like Harlan Crow and Federalist Society dark money expenditures are fundamentally perverting judicial ethics and undermining justice and the rule of law. Now, apparently responding to the national outcry over this ethics crisis on the court, our colleagues have called a hearing today about the influence that wealth exerts on the justice system, but they've gone off on a surprising and bizarre tangent. The problem, they say, is not the way the public is harmed when billionaires bankroll the private lives of ethically challenged Supreme Court justices. The real problem is that giant corporations are harmed when Americans injured by toxic torts or environmental crimes receive contributions from donors to help them bring personal injury or class action lawsuits. Now, we say justice is blind because the Greek statue for justice wears a blindfold. In solving cases, justices are supposed to be blind to wealth and poverty, personal friendship, and political affiliation. A poor person who has never met a judge must be treated the same by the courts as Harlan Crow, the real estate tycoon chum of Justice and Mrs. Clarence Thomas, who had a case before the Supreme Court and who has given the Thomases lavish personal gifts like week-long luxury travel on his super yacht and private jets and generous money payments for family tuition over a period of 20 years ever since Thomas joined the court. A collector of not-so-fine art created by dictators who actually owns and displays 2 paintings done by Adolf Hitler, Mr. Crow donated $105,000 to the Yale Law School in 2018 for another painting he desires, writing a check to the, quote, Justice Thomas Portrait Fund. But Justice Thomas isn't unique. He's just emblematic of the collapse of legal ethics across the street. Justice Alito took a long fishing trip with a hedge fund magnate who's had business before the Supreme Court 10 times in the last 15 years. Neither justice recused himself in the relevant cases or made any relevant, timely disclosures. Justice is supposed to be blind to the blandishments of money and class power. It's only supposed to see the facts and the law, but in the Roberts Court, judicial vision is clouded everywhere by dollar signs and luxury power trips. The facts and the law are barely visible when it comes to the rights of workers trying to organize a union, or poor women seeking abortions, or consumers injured by adhesion contracts and corporate ripoffs. If we're going to return to equal justice under law, as it's written over the entrance to the Supreme Court, if we're to make justice blind to the wealth and the identity of the parties in the courtroom, then our justices must be held to the highest ethical standards. And yet, amazingly, the justices are not even subject to the basic code of conduct for United States judges that all other federal judges are subject to. The 9 justices are, in fact, not bound by any ethical standards at all, much less the comprehensive ethics code that applies to all the other judges. Their decisions can affect or destroy the rights of all Americans, but the justices refuse to abide by any written ethical code. They decide on their own if their work is impaired by a real or apparent conflict of interest, a terrible system which cuts against the key principle of justice that Madison articulated in the Federalist Papers. No man is allowed to be a judge in his own cause, in his own case. The highest court in our land now has the lowest ethical standards. This is the crisis we should be discussing today. But our colleagues have instead called a hearing to assert that it's just too easy to haul corporations into court when they violate other Americans' rights. The third-party litigation funding under attack today is the only way that a lot of victims of corporate misconduct can even get into court. Do our colleagues really want to make it illegal now to receive contributions to vindicate your rights? I could understand if they were saying that all the present federal rules of civil procedure against frivolous, vexatious, and groundless litigation weren't working. I could understand if they were arguing that Rule 11 sanctions against baseless lawsuits needed to be expanded or fortified, but that's not what they're saying. They're not citing any kind of increase in frivolous or meritless litigation, nor are they arguing that current sanctions don't work. Those sanctions are working just fine. No, they're looking for ways to reduce the prosecution of merit-worthy and successful lawsuits against actual corporate wrongdoers. And by pulling the rug out from underneath actual tort victims, they hope to keep plaintiffs from even getting into court. The GOP wants to dramatically reduce accountability and liability for corporations that flood our country with opioids to make obscene profits, corporations that poison our communities with asbestos or lead and other dangerous carcinogens, and corporations that inflict black lung disease, mass oil spills, and other lethal injuries on American communities. Victims bringing these lawsuits, especially those who are low income or unable to work because they're sick or injured, often cannot afford to bring the lawsuits at all without financial help from other citizens. If their lawsuits have no merit, they should be thrown out. But if they have merit, then we should all be grateful that they are working to make society safer by stopping the wrongdoers before they commit more wrongs against society. Many landmark cases establishing the basic rights of Americans have been funded by contributions from outside groups: Brown versus Board of Education, Loving versus Virginia, U.S. versus Windsor. The corporate interests represented on the panel today who are attacking this basic right are here for an obvious reason. They don't like paying damages when their victims prove their rights have been violated in court. Johnson & Johnson has had to pay billions of dollars for its central role in the opioid epidemic, and billions more to tens of thousands of people who develop cancer because of the country's dangerous talcum powder. Mining and offshore drilling companies have had to pay billions for poisoning communities' land and water and causing irreparable harm to human health. Perhaps one of the biggest environmental cases in the history of the United States, oil company BP agreed to pay $20 billion for damages caused by the Deepwater Horizon oil spill in the Gulf of Mexico. One can only regard with amazement the fact that our colleagues are in such a hurry to promote the grievances of these big tortfeasors and wrongdoers that they don't even pause to consider that there are hundreds of millions of dollars in right-wing third-party litigation financing regularly bankrolling anti-choice, anti-LGBTQ, anti-gun safety lawsuits, among many others. Well-funded right-wing networks like the Pacific Legal Foundation, the Koch Network, the Judicial Crisis Network have poured hundreds of millions into remaking America through the courts on issues ranging from attacking public school curricula to opposing compulsory union dues to repealing the Consumer Financial Protection Bureau. The Alliance Defending Freedom and other right-wing groups brought the Dobbs case and are working to eliminate access to abortion for all Americans. That's their right. Our colleagues don't complain about that. In fact, they don't even mention it. Are they willing to sacrifice the rights of their third-party litigation financiers on the right, or are they just not serious about this whole thing and simply looking for another catchy way to distract everyone from Donald Trump's 91 different criminal charges in 4 indictments across the land? Everyone knows that a fish rots from the head down, and everyone knows what stinks to the high heavens in the judicial system today is, alas, the Supreme Court itself. Let's focus on where the corruption of justice is actually taking place today. Thank you, Mr. Chairman, and I yield back.
Thank you very much, Mr. Chairman. I want to thank all of our witnesses for being here today. And it's apparent that we're here today because our Republican colleagues are worried that it's too easy for the American people to bring legitimate claims against big corporations that poison and pollute our communities. And as they put it in their press release when they announced this hearing today, they're concerned that, quote, financiers are hijacking America's courtrooms. So if they want to talk about money in the court, let's talk about Justice Clarence Thomas and the many allegations of ethical lapses and conflicts of interest that came to light just a few months ago. So we're going to keep this simple. Now, first, I have a photo here. We see Justice Thomas with his very generous friend, Harlan Crow, who we've heard a lot about. We know that Crow is the conservative billionaire who has poured enormous amounts of money into Republican causes, funded right-wing advocacy organizations, including those, of course, run by Justice Thomas's wife, Ginny Thomas, who has had, of course, cases before the court. Now, some of these gifts that have been given to Crow by Thomas, let's list those. Justice Thomas regularly stays at Harlan Crow's private lakeside resort in New York, which I hear is very lovely. In 2017, Justice Thomas stayed at the resort with fellow guests from Verizon, the American Enterprise Institute, and PricewaterhouseCoopers, to name a few. In 2019, Justice Thomas flew on Harlan Crow's private jets and enjoyed 9 days of island hopping in Indonesia on Crow's 160-foot yacht, which I've never seen a yacht that large. I'm sure it's very lovely. It came with servants and private chefs. If Justice Thomas had actually chartered that yacht himself, it would have cost him $500,000. Now, Justice Thomas also accepted a $19,000 Bible that from Harlan Crow, of course, that once belonged to Frederick Douglass. And apparently, so this must be the same Bible that the justice is using to take away rights from women and gay people. Now, Harlan Crow's foundation also made a over $100,000 donation to Yale Law School for the Justice Thomas Portrait Fund. Now, Harlan Crow purchased Justice Thomas' family home and a property where Thomas's mother has lived rent-free. And Thomas Crow also paid the boarding school tuition of Thomas's grandnephew, Harlan Crow, valued at over $100,000. So the list, of course, goes on and on and on. And if this isn't corruption, I don't know what is. Now, Professor Clark, I want to thank you for your testimony today. How was Justice Thomas able to accept these lavish gifts? And how is it possible that a sitting Supreme Court justice can take so much without scrutiny?
Congressman Garcia, Supreme Court Justice Thomas has engaged in this practice of receiving these lavish gifts, as you outlined. And even more disturbing, in my view, is the fact that he failed to disclose those gifts, or many of them. And he has gotten away with failing to disclose until these gifts and other inaccuracies were discovered by journalists or other non-government organizations. So there is a lack
And
of
we're to assume
accountability.
that Justice Thomas is trying to keep these things hidden from the public. I mean, he did not disclose his gifts. Was that your assessment?
Yes, it is true that he did not disclose these gifts.
And so what he chose not to disclose was traveling on lavish large yachts, was being treated to the best food, was traveling in Indonesia, was getting $20,000 Bibles, was gifts to his favorite charities, and he chose to not disclose any of these information to the public. Is that correct?
Congressman Garcia, I believe that the Bible may have been included on one of his
Good for him. That's good for him.
I think that everything else you mentioned, he did not disclose until called to account.
Absolutely. And of course, we know the issue, of course, is not just the gifts themselves, but it's actually the disclosure process. We also, another issue is that some of these gifts have had connections to cases that have been in front of the justice himself. And so these are with other business histories tied to Mr. Crow. Now, this is what happens when we combine big money donors with weak judicial ethics rules. We must do more to bolster the integrity of the Supreme Court. I want to thank Ms. Clark for your work in these efforts. Like all of us on our side of the aisle, we want to put the American people before corporations and put the Constitution above conflicts of interest. Thank you, and I yield back.
While I'm thrilled with any and all opportunities to talk about judicial ethics, I also find it very telling that my Republican colleagues only want to discuss it when corporate CEOs are the so-called victims, not when dark money funded and fueled the overturning of Roe or the rollback of LGBTQI plus protections or the reverse of student loan relief and the end of race-conscious college admissions, not when it was revealed that two of our most right-wing Supreme Court justices, Alito and Thomas, had been bought and paid for by billionaires like Harlan Crow, who, among other things I'll get to shortly, footed the bill for Justice Thomas's flights and private jets and lavish vacations. And not when these same dark money mega donors pushed radical, often unqualified judges onto the federal bench, further eroding the legitimacy of our court system. We all know that wealthy right-wing donors have increasingly formed covert operations using money and relationships with powerful people in Washington to support strategic litigation for Republican culture war causes such as ending the acknowledgement of systemic racism in college admissions. One of these operations is Donors Trust, funded by a largely anonymous group of Republican mega donors, though it has been linked to major right-wing funders such as the Koch brothers and Leonard Leo. Professor Clark, why do you think dark money organizations such as Donors Trust want to hide where their money is coming from, and do you think that's ethical?
Congresswoman Lee, I believe that the record is rife with examples of wealthy trusts and institutions and foundations attempting to exercise influence and also attempting to hide their exercise of influence. Because to the degree to which the public knows about it, there can be a backlash against it.
So throwing a stone and hiding her hand.
There's, I believe, a long record of that.
Thank you. According to their 2019 IRS filing, Students for Fair Admissions, the organization behind the end of affirmative action, received 65% of their funding from just 3 mega donors, including Donors Trust. Professor Clark, what are the ethical concerns of dark money groups, and do you think the affirmative action and student debt cases, for instance, ruled on this summer would have made it as far or been as successful without these donors?
Congresswoman Lee, I believe that dark money and hidden financial influences on our political system and on our judicial system can sort of undermine the ability of people at large to exercise their rights, participate. And so while this is not a matter of legal ethics as such, I think that scrutiny of how hidden large expenditures influence our political system and judicial system is important.
Thank you. In the last decade, billionaire hedge fund manager Paul Singer has contributed over $80 million to Republican political groups. Specifically, Singer gifted millions to the Manhattan Institute, a conservative think tank where he has served as chairman since 2008. The Institute regularly files friend of the court or amicus briefs with the Supreme Court, at least 15 this term, including one asking the court to block student loan relief. Singer also gifted a luxury fishing trip to Alaska on a private jet to Supreme Court Justice Alito, who went on to decide the case blocking student loan relief for 40 million Americans, including me. One of these Leo and Koch-backed dark money operations donors' trusts then became the deep pockets funding the end of affirmative action decided by the court in July. And another billionaire hedge fund tycoon who flew another Supreme Court justice, Alito, to another luxury vacation via another private jet as he gave to another conservative think tank working to block Biden's student loan forgiveness plan, got his way to the cases before the Supreme Court that same day in July, blocking debt relief for 40 million Americans. To conclude, I want to say, like so many Black Americans, the one-two punch of student loan forgiveness and affirmative action designed to cement this country's already existing racial wealth gap left me feeling deflated, and they punched down on so much talent, so much brilliance by shutting Black students out. It leaves us feeling like we're running out of options, like we're powerless against those with endless money and power to rig our legal systems to benefit themselves. And yet, my Republican colleagues seem far more concerned with protecting Johnson & Johnson's ability to shield themselves against liability from their carcinogenic talcum powder that caused Black and brown women to develop ovarian cancer than protecting the American people against the capture of our courts by dark money networks and the business of selling out our freedoms in exchange for control of our
The
judiciary.
gentlelady's time is up.
Thank
We're over.
you, but
Thank
someone
you.
went 23
You
seconds
sound
over
great.
last time.
I know, you
Miss
sound
Mace,
great.
But
You
the
sound
last
great.
chair went 23 seconds
45
over.
seconds
You
over
just used
time.
15
You're
of those
fantastic.
seconds for
We're
me.
over. We're done
I
here.
just
We're
want to make
moving
sure
on.
that we're fair.
Okay, I would like to recognize my fellow congressman from South Carolina, Representative Timmons.